Dear ladies and gentlemen, it is a great honor and pleasure to welcome a good old friend in our circle of the lectures of the Transatlantic Legal Online Lecture Series. I'm talking about Professor David Kohout, who has been for many years head of the international office of his faculty, a very dear partner of our network, the Charles University, the historic Charles University of Prague. And he is an eminent peer of our network. He is a highly recognized specialist in matters of sports law, which today is going to be the core topic of his lecture. But not only that, if you consider his wealth, his palmarès, as our French friends would say, of publications, you will also see very interesting publications in regard to matters of international law. Namely, I'm gonna talk about an article of 2017 named Statutory Limitation of Crimes under International Law, Lessons Taken from the Prosecution of Nazi Criminals in Germany after 1945, and also another very eminent contribution of 2016 about the topic implementing the Nuremberg Principles in national trial with Nazi criminals, that emphasizes that our dear friend and lecturer of today's edition has a very wide scope of scientific legal interests. Therefore, with no further ado, I'd like to present our dear friend, Professor Kohout, to you, and please enjoy.
Thank you very much for the very nice introduction and a very diligent research as to my academic background, Dimitrios. Thank you very much. I'll try to limit my speech to about 1 hour because I understood that this is kind of customary duration of each talk in this series. And on top of it, of course, we may allow additional time for discussion, questions, and so on, if this is fine. And I believe that Dimitrios is acknowledging this proposal. Thank you very much. When we discussed the topic that I could present originally, I was proposing either a more general topic, which would be like an introduction to the topics related to sport and law, law and sport, or something more narrow, but we figured out that maybe sports law is not a subject which would be taught at all the universities and that the students would be dominantly familiar with. So we decided to move in the direction of this rather general topic. I'll try to divide my speech into two parts, one being really like general introduction to how the sports environment, sport organizations, and other stakeholders or actors involved in this field operate under the legal framework which exists for this kind of activity. And then later on, I would like to present, you can call it ideas, problems, cases, which are related to this general subject. And I'd be happy if you could intervene if you had any questions, something was not clear, if you thought that you disagree, and so on and so forth. I think this is really like an open stage for everybody, and I'd be happy if you accepted the invitation for the discussion. Before I manage to share my slides with you, I'm sorry, I'm not 100% familiar with Zoom. That was not the main platform that I had been using or have been using since the pandemic, but I think I got it. Yep. Not sure if you see it full screen or how it works, how it looks for you.
It's half screen, but it is manageable.
Okay.
We can see.
Okay. I'd rather. Okay, is it full screen now?
A little bit fuller, but then again, that should not be an obstacle. It's fine, I guess.
Thank you.
It's visible.
Thank you very much. So yeah, the topic that I chose is law in sport, sport in law, specificity of legal relationships in sport. And I would argue, even though it's not that known field of law everywhere, that sports law has become a very sophisticated patchwork of many different fields, and there are many fine subtopics which could be elaborated into depth, both from the academic perspective, but also when you look at the legal practice. But I don't think that we have the space for it, and as we decided to choose rather this general focus for the class, I'm going to limit my presentation to this general introduction and to, let's say, selected topics from sports law. Before moving to the subject itself, I actually wanted to present our activities related to sports law in Prague, because perhaps some of you might be interested in the field and you may think about going to Prague for Erasmus within the LPIS framework. So what we have are activities which are primarily in the Czech language, and we have activities which are primarily or fully in English. Sports law has been developing at our law school since 2007, and later on it gained also other forms than the original one basic course. So nowadays, every year, we tend to organize a summer school on sports law for the Czech students. We have 2 courses in our curriculum dealing with sports law. We have a specific course on sports law for exchange students. We have an LLM in sports law in the Czech language. Then we have an LLM program in English, which combines 2 specific fields, which are not that much interlinked, but I think still there is some kind of connection, even though a minor one, and that deals with medical law and sports law. So this is this LLM in health and law. We try to organize internships for our students in sport associations. So we have had students with Czech Olympic Committee, Czech Football Association, sport clubs, and so on. And last year, last academic year, we participated, or our students participated in an international sports law moot court for the first time. And for the year 2023, we have had an approved project for Erasmus blended intensive program in sports law.
Excuse me, may I interrupt? Sorry.
Sure.
I think that you have these information also put on the second part of your slides. Is that right? Because
exactly.
it hasn't changed. Maybe it was intentionally or not. Just for our participants also to see it.
Okay. Thank you. Thanks for letting me know. And is it now visible, like the second slide?
Yes. Now we can see it perfectly well.
Okay, so I'll rather use this format of showing you my PowerPoint. Someone's trying to get into my office, but I have the keys from the inside and it's locked, so hopefully it's bad luck for the person. I will move to the actual start of my class, and that is the overview of actually the underlining quote in the topic of my lecture, sport in law, law in sport. Is there a difference? Do you feel a difference? I think the difference is in which perspective you take. If you're a lawyer, like this guy with the basketball, then I think for you it's more about law, but you also have to have some feeling for sport if you deal with these matters. First of all, it is because you will be dealing with people from the sport environment, and I think they are quite often quite particular. So you have to be able to share their emotions about the game, whatever sport it is. Second, law in sport. If you are an athlete, of course, the performance is what really matters for you. If you're a professional athlete, we will mostly be speaking about professional sport. But on the other hand, if you're like an amateur athlete or you do sport for fun, doesn't mean that no regulation applies to you. In fact, you are also subject to rules which are connected to sport. And sport rules doesn't mean that if you play, not necessarily, that if you play football, it means you play 11 players on one side against 11 players on the other side, and the purpose is to get the ball into the other team's goal. The regulation of sport is connected with issues like contractual framework for sport, civil liability in sport, anti-doping regulation in sport, organization of large sport events, and the underlying principles for it, and so on and so forth. So if you're an athlete, not necessarily only an athlete, but someone who is not a lawyer, but still someone active in the field of sport, you should have some awareness about law as well. For instance, when we look at the topic of doping, it is always the athlete who has the objective responsibility for adhering to the anti-doping regulation principles. It's not that he could liberate himself from this liability by saying, I let someone else to take care of it. Of course, in practice, they would have their, like the superstars in sport, the top athletes, they would have their management team who in fact would perform many duties and would advise them on the legal aspects when negotiating contracts, could be sponsorship agreements, could be professional contracts between clubs and players, and so on. But the player, in fact, is the one who bears the responsibility and who is part of these regulatory and contractual systems. So altogether, if you look at it from both of these perspectives, we may argue, at least for the purposes of this class, that it really makes sense to establish something what would be commonly referred to as sports law. In fact, you would find scholars arguing that there is nothing like sports law. And to some extent, in fact, to a great extent, I would support their arguments. But on the other hand, I think if you look at the legal practice and if you find yourself interested in the field of sport, you would find out that having an expertise in sports law as an attorney would be quite an asset for your career in many cases. Not every attorney would deal with cases from the era of sport, but in the Czech Republic, in Germany, I'm sure in Portugal, in Italy, especially in these like football superpower countries, you would have super niche specialized law firms dealing virtually only with sports law and being sought for because of this special expertise. In order to gain this expertise, listening to this class is of course not enough for you. There is like a very intricate system of rules, which we will shortly look into in a general overview, but also there is a tremendous amount of jurisprudence and case law, which would be something that you could not avoid if you wanted to become a lawyer specialized in sports law. This case law mainly would be delivered by bodies of sport organizations and by specialized arbitration tribunals which deal with sport cases. But on the other hand, you may sometimes also come across cases which are dealt with on the European level by, let's say, the European Court of Human Rights, the Court of Justice of the European Union, or even by national courts on the domestic level of the individual countries. So why should we take a specific look at law in sport or sport in law? Sport, we may say, has some specifics. It's something what is not only like a colloquial expression. It's something what the European courts have been dealing with since 1970s. There has been some kind of development of the case law, and I'm not going to spend too much time on this European jurisprudence on sport, because I understood from the list of the lectures in this series that there is going to be one additional class on sport in the context of the European Union law, and mainly the competition law rules. So I will just limit myself to mentioning that sport is not something what would be part of the exclusive competences of the European Union and its bodies. And it's not even listed among the shared competences shared between the European Union bodies and the member states. So in fact, you may think that sport has nothing in common with the European Union law, but to the contrary, and through the case law of the Court of Justice, the relevance of the European Union law for sport has become quite significant. Not in cases which would deal only with something what would be confined to the sport itself. So the European courts would not deal with an outcome of a match, for instance, in football. But according to the jurisprudence, whenever sport has some kind of economic dimension, which is relevant for the internal market, it could be affected and is affected by the European Union regulation. The specificity of sport originally meant that sport, in as much it is not an economic activity, would not be subject to the review by the European courts. But given the ever-increasing professionalization of sport, the economic aspects which are related to sport, not only in terms of marketing agreements, but also in terms of sport being exercised professionally, and also in context of, let's say, even international championships, which are not anymore about only about representing one's nation, one's country, but are also connected with financial remuneration and other considerations like this. In fact, we can say that sport is no longer exempted as such from the European Union law. And on the other hand, these cases of its specificity are dealt by the Court of Justice of the European Union on the basis of reviewing possible justifications. Because in sport, you have some concepts which would not be common to other economic areas. In sport, when we take a look at it from the level of sport competitions, you don't want to be the sole competitor, for instance, not in terms of necessarily competition law, but in terms of having various actors acting in the same area. That's one perspective. Also, you have certain rules which need to be adopted for organizing these competitions and the whole system which is behind that. If you look at the World Cup, FIFA World Cup, which is ongoing right now, you will see that the match itself is just the peak of the whole FIFA organization. You might have noticed the discussions about the armbands for the team captains and so on and so forth. And you could see that there are rules for the kit that the football players should wear, which were adopted by FIFA and which are mandatory. If you don't follow these rules, you may get sanctioned. So there is some kind of disciplinary system which is not based on criminal law, administrative law. It's not an administrative offense. It's only an offense because FIFA considers it an offense and has such offense included into its regulatory framework, which is really vast. And on top of it, you have to consider that it's not only football, but every different sport has its own set of internal rules for the organization of the competitions, but also for the organization of the other aspects of their sport discipline. You may find rules referring to the practice of coaches. So what kind of standards you have to meet in order to become a coach for a team on this level. If you are to practice as a coach on a higher level, you have to perhaps have a higher qualification, which again would be obtained through some kind of organized schooling by or within the sport association. The way how the system of sport stands is based on something what many would call a sport pyramid. You can look at it from different angles, but the first angle that we would take is the perspective of the stakeholders which are active in the field of particular sport discipline. In this scheme, who sits on the top of the pyramid? It would be the International Sport Federation. Then below, like FIFA in football. Football has the most sophisticated system of the regulation and also most case law. So usually football would be, or also due to its popularity, football would be chosen as the example for the description of these principles. On the other hand, if you looked at other sport disciplines, be it volleyball, handball, and so on and so forth, there might be some differences, but the general principles would work just the same like they work for football. So FIFA sits on top because FIFA, according to its statutes and according to its position, is acclaimed as the supreme organizer of football in the world. It is the organization which has the economic rights to organizing the World Cup, for instance. It's not Qatar, it's the FIFA. And also it is the one who sets the basic rules for all those who are below in the pyramid. So FIFA has certain provisions, for instance, on the stability of professional football contracts, called FIFA regulations on the status and transfer of players, which are universally valid throughout the whole world within football. Why? Because of something called membership principle. These are associations, as it is highlighted here in the slide. And the associations, you may recall from your national legal order, are based on their members. So the basic feature of an association is that it is composed of several members. And becoming a member within an association brings you some benefits. Otherwise, you would never become a member. But it is also combined with certain obligations. How do you learn about your rights and obligations? Of course, some of them may be based directly on the provisions of law, but on the other hand, most of them would be within the scope of the applicable general domestic or international or EU law, would be outlined in regulations of the International Sport Federation. And they would be binding upon the members. So FIFA has several members or types of members. First of all, the continental confederations, so like the UEFA, European Football Association, African Football Confederation, and so on. There are 6 of them. Then membership in FIFA hold also national sport associations for football. So the German Fußballverein, Verband, or the Verein, I'm not sure now. Czech Football Association. There is one in virtually every country. So there are, I believe, 211 national football associations worldwide. There is always one football association which is recognized by FIFA per country. There is an exception. In the UK, you have Wales, Northern Ireland, Scotland, and England, but only because of historical reasons as a deviation from the general rule. Otherwise, the system is based on the principle one association per country. And that association, by the same token, is the supreme organizer of football competitions in that given country. So in the Czech Republic, the only one who has the authority, unless delegated somewhere, but still bearing the responsibility for football competitions, is the Czech Football Association, which is the only one who reports to the UEFA and to the FIFA. The clubs themselves would somehow be members of the National Football Association. There might be different ways how this is done, but on the level of clubs, it's quite universal that they are required in order to be able to participate in the competitions organized by the National Federation to be members of the National Federation. And only by being member and participating in these competitions, then according to some qualification criteria set up by, let's say, UEFA, they would be eligible to take part in, let's say, UEFA Champions League. Otherwise, being outside of this system, like there was this Super League concept, which will be discussed without any doubt in the next lecture by my colleague, they would never be allowed to participate in this type of competitions. And on the bottom line, you would find different individuals or even legal entities. There could also be not only athletes, coaches, agents, but also athletes' trade unions. In some countries, there could be other associations, other affiliated members, and so on. And they would normally be members of the association on the national level, either directly. Sometimes there is so-called indirect membership. So the athlete is somehow member of its club, and by subscribing to the rules of the club, they would also be bound by the rules of the National Sport Federation, because the clubs have to subscribe to the rules of the National Sport Federation. The meaning of this pyramid is that whoever sits higher above you may prescribe some rules for you, for your conduct. And as long as you want to remain within this system, because, well, it's interesting for you because you want to play football and you want to take part in the competitions, as long as you want to stay in the system, you have to observe these regulations, even though these regulations were not adopted by national parliament, let's say. So they are valid not for someone like me, let's say, if I was outside of the framework of the football association, never playing football, not being part of the management of the association and so on, then I would never be affected by the rules which would be framed by the football association on any of these levels. But if I want to play football, then I have to become a member, because that's the ticket for taking the ride in the system. And if I take the ride, I enjoy playing football, then I also have to respect my duties. And if I disrespect these duties, there is also an internal disciplinary system which may lead to my sanctioning. So this was a brief introduction of the sport pyramid from the perspective of sport associations, but we can also look at it from a different angle, being the sport pyramid in terms of the rules applicable to sport. And also in this case, you may see that there is some kind of hierarchy between the rules. So on top of it, we may say that there are mandatory provisions of mainly the EU law. The European courts have already said before that the rules of sport associations, which would start from here and continue here and here, they are subject to the provisions of the European Union law, as far as they have some kind of effect on the freedoms within, or in general, EU law freedoms and rules for the internal market. So it's not only state law which has to be in compliance with the EU law rules, but also the internal regulation of sport federations. Then on the next level, from top to bottom, would be the national law. And here we have to distinguish between mandatory norms of the national law, which cannot be overridden by any inferior regulation by sport associations, and let's say non-mandatory optional norms of the national law, which are only provisional unless the individuals and legal entities do not have a different setup in their contractual relationship. And we may say that all this, like this pyramid of associations, individuals, and entities, is based on a contract, because entering an association, this whole system is, and we may argue to some extent, we will see that there is also other consideration, but we may say it is a voluntary act of the one entering the system and voluntary act of the respective federations which accept that individual legal entity as a part of the pyramid of the system. So there is always some kind of contract. So insofar, the rules of sport federations are in compliance with the EU law, eventually public international law, but not that much. These don't have that much of a direct effect, of course, towards international sport federations, but they may have impact through the norms of mainly the national law in some cases. But in as much as there is some space for further regulation, the sport federations may adopt rules for conduct of those who are their members or who are somehow entangled in the system of the given sport field. And in fact, because we're in the field mainly of private law, definitely in the sphere of private law, when we look at the internal organization of sport associations, which are private entities, there is a lot of space for further regulation. And again, even on this level, there is some kind of hierarchy. So if FIFA has some kind of general regulatory framework for sport activities, for instance, as I have already referred to, when you're entering into a professional contract, when you're a football player, you have a contract with your club, no matter whether you are in Brazil, in the Czech Republic, in Portugal, in Germany, the same rules would apply to this contract, the same rules issued by FIFA and further implemented by either continental confederations or national football associations. So this would be the brief introduction of the general scheme, how it works, which I thought on the presumption that not everybody has been familiar with the concept how sport field operates was necessary before we move on to the second part of the talk of today. And these would be already some rather selected issues. We could have chosen other ones, but somehow I thought that these could be interesting, thought-provoking, and so on. One of the concepts that you may often find in the area of sport federations is the declared autonomy of sport associations. This autonomy often comes from domestic legal orders, because the freedom to associate is not only part of international human rights documents, but also as part of mainly civil rights, but also it is often used in human rights bills of individual countries. That's one aspect. So the autonomy of sport associations means that the state would not interfere with the organization of sport associations. Further, meaning that also the sport associations have the freedom to adopt their internal regulations, in as much it does not contravene the mandatory provisions of domestic law or EU law and so on. The autonomy of sport associations, on the other hand, is also declared within the pyramid of sport associations. This excerpt has been taken from the FIFA statutes, the latest edition, which says that member associations have to manage their affairs independently and ensure that their own affairs are not influenced by any third parties, in accordance with Article 19 of these statutes. This means that also FIFA wants the football world to remain mainly politically neutral, and outside of the influence of any other interest groups, which we may have a discussion about, but in fact, this is the general rule. They are asking for freedom for all. But at the same time, FIFA also has certain overview. It also puts itself into the position of the watchdog of the whole system, and it has provisions on, let's say, dealing with disobedient members in a way, or members who happen to be somehow under undue influence of other entities, mainly by states. So what could happen, according to FIFA, with these either disobedient or unindependent members? FIFA may either suspend their membership rights, which in fact would have serious consequences for the countries involved or the national football associations. By having your membership suspended, you may not take part in the competitions which are within the whole FIFA framework on the national, continental, and international level. Or you can play your own competition nationally, but it will not be recognized by the higher levels. So on the continental and global level, you cannot take part in the competitions of the national teams, but also your clubs may not take part in the international club competitions, which of course is very painful situation for you. And it's not that rare that some of the associations would be suspended. This happened, for instance, not sure, it could have been something around 2015 to Indonesia, which just to keep it short, there was some, in the eyes of FIFA, there was some kind of undue influence of the state in over the Indonesian Football Association, and So they pronounced suspension of the membership rights with all these effects, including also the effect that the suspended national federation may not draw any subsidies from the continental or global football federations, which is also extremely painful. And in fact, for the federation itself, it may have like a very vital effect. But the sport sanction, or this sport suspension, had the effect that even the Indonesian government, and there are quotes of it, it's, as long as I can rely on the quotes which are generally available, the government, by the Ministry for Education, by the Minister for Education and Sport, even issued public apology to FIFA for messing up with the football affairs. So they said that they understand now, that they understand that what they did was not correct, and that they have to amend the situation in the way which would be in compliance with the FIFA rules, which, if you think about it, is quite striking. If you compare, and Indonesia is not like a tiny state somewhere, it's like one of the great powers in their part of the world, that's a public official, very highly ranked public official, in fact, issues an apology to a sport federation, even though it's the largest one in the world. But you can see how sport and politics also could somehow be interlinked. And in this line of arguments, you may even think, and I'll leave the thinking to yourself, whether FIFA should or should not get involved in like all these debates about human rights, whether their capacity to exercise influence over the political issues should or should not be used more, or even on the other hand less, in the nowadays world, because you can see that the real power of FIFA, in fact, is, I think, tremendous towards the governments of the individual countries. Because if you have a country which is crazy about football and you take the toy away from your citizens, it could have very, very bad influence, very bad impact on your political standing later on. So that was to the possibility of suspending a member and its implications. But there is also something what may further be used by FIFA, apart from yet another tool, which would be a complete expulsion of its member. To my knowledge, there has been no case of that, meaning FIFA would terminate the membership of one of the, let's say, national football federations. But there is something what is called a normalization committee, which, according to the wording of the recent FIFA statutes, is the case, excuse me, when executive bodies of member associations may, under exceptional circumstances, be removed from office by the FIFA Council, and so on and so forth, and replaced by a normalization committee for a specific period of time. Sorry. I don't know if you have any particular feelings about the term normalization committee. If not, I wouldn't blame you, but it means you don't come from the Czech Republic, because the idea of the normalization committee with respect to the Czech Football Association was once presented here as well. It is sometimes used. It's not that common that every second football federation on the national level would be under the control of the normalization committee, but definitely there have been like quite a few cases when the normalization committee was instituted. But there was a threat that something like that would be also put into effect in the Czech Football Association, for the reasons that we have a very specific system of electing the president and the executive board of the Czech Football Association, and it often leads into a situation that the elections are unsuccessful, no one is elected, and that had been annoying UEFA and FIFA for some time, because for some period of time we were even without regular representative in the lead of the Czech Football Association, because of this procedural, mainly basically procedural problem with elections. That happened, this particular case happened in December 2017, when the Czech Football Association was holding its General Assembly, which was to elect the new president of the Football Association. And UEFA and FIFA sent their representatives to this General Assembly. And one of them representing UEFA was its vice president, Georgy Surko, Ukrainian, who delivered a talk to the audience within the General Assembly. And he said that this system is untenable, the system for electing the president, and that we have to become obedient members of FIFA and UEFA once again, and we have to yield to the democratic will of the majority, and that all these bad rules, which make the procedure ineffective, should be cut out as a tumor. Otherwise, a normalization committee could be instituted in the Czech Football Association. And now comes one of the points that I'm going to make. First of all, the general connotation of the situation. The person, Mr. Surko, who, by the way, has been prosecuted in Ukraine for embezzlement and other potential crimes over the past couple of years, without, to my knowledge, any outcome yet. So, well, of course, we should deem him innocent. But anyway, just adding to the picture, Mr. Surko was presenting his speech in Russian, and using the term normalization committee is something referring in the Czech Republic back to 1968, when there was this Prague Spring movement during the communist regime, which was trying to somehow ease the communist supervisory power in the country, still remaining a communist country, but with a more relaxed atmosphere, more relaxed conditions for the individual businesses, for instance, and so on. And that led, besides other things, to an intervention of the Warsaw Pact armies in Czechoslovakia in 1968, in August. And that started a period which is often referred to in the Czech Republic as normalization. So bringing, in the communist meaning of the word, bringing the public affairs and private affairs back to normal. Back to normal in the sense that normality meant everything would be kind of uniform, would be under the review of the communist regime. So this has very negative meanings, connotations in the Czech Republic. Given the fact that it was connected also with the other statements which I referred to earlier on, and the speech was held in Russian, this had very, let's say, debatable, this left very debatable impression to me, and I think quite many people alike. But it has also other issues which are more legal and which I think are connected to something what I called here the tensions between the idealistic idea of the sport federations, how their world would be organized, governed by them, and the reality of the legal system worldwide. The problem is that even though the international sport federations adopt some kind of regulation, usually most of these international sport federations for most of the sports are based in Switzerland, which has very relaxed regulation as far as the freedom of association is concerned. They adopt something and ask or require all their members, meaning all national associations, to implement these rules in their systems. But what is sometimes difficult about it, and what sometimes I believe FIFA and UEFA and other large international organizations, associations may not fully grasp, is that they would be implemented in like 208 different national legal systems. And the national legal systems would, as you look into the pyramid, they would prevail over the regulations of even FIFA in the legal meaning, not perhaps in the meaning of the real practical functioning of the world, like the example of Indonesia at the end of the day. But in the theory, in what is, let's say, obvious from the hierarchy of the norms, even FIFA regulation stands below national law of the country where it should be applied. So sometimes this leads to issues where there is a conflict between, for instance, FIFA rules and Czech national law or national law in other countries. And I believe that this is exactly the case, even though there have been normalization committees in other countries. At the end, FIFA did not decide to implement one in the Czech Republic. And I think even if it decided so, it would not be consistent with the Czech law, because according to the Czech law, Czech Civil Code, the supreme executive body of an association, no matter whether it's a sport association or gardeners association, association of people collecting stamps, whatever, but there has to be the executive body, and the statutes shall give out the reasons, or should outline the procedure how the executive body is elected and appointed. If you look into the statutes of Czech Football Association, there is no mention of a normalization committee whatsoever as a part of the structure of the Czech Football Association. Now, because also of the time issues, I will be simplifying it a little bit, but my main argument is that even though Czech Football Association is bound by the whole framework of the regulation issued by FIFA, you cannot infer the argument that by this very general reference in the Czech Football Association statutes to the general framework of FIFA, one could say that FIFA has the external power to change the structure of the bodies, statutory bodies of the Czech Football Association. Also, if you looked into the Czech Act on the registers, public registers, the people in the executive bodies of associations have to be included in the registers. And I think you cannot infer that someone from the outside, like FIFA, could successfully, without cooperation of the Czech Football Association, manage to change the structure of the bodies. So this would be the legal perspective. I believe that in the practical, in the real world, if FIFA decided to establish normalization committee, which would, as you can read here, would take over the role of the executive bodies of the member association. The Czech Football Association itself would cooperate with FIFA, and it itself would try to appoint this normalization committee in line with the Czech national legislation. So, meaning perhaps changing their statutes or electing the candidates prescribed by FIFA into its own executive committee, just to fulfill the criteria by the FIFA, exactly for the reason to avoid being suspended by FIFA and losing all the benefits of the membership. So this is the tension between the legal world and the real world on another example. I think we're slightly running out of time, so maybe my second example, just in a nutshell, it's there are two more slides. The dispute resolution in sport is also a particular issue which is nowadays becoming challenged before even state and international courts. One of these challenges, so far not successful, but still not fully closed, is the famous Claudia Pechstein case, so German case of speed skater, ice speed skater Claudia Pechstein, who was found guilty by the international skating union bodies, disciplinary body, to guilty of a doping trespassing. So she was believed to be abusing or to be violating the anti-doping rules. She then turned to the Court of Arbitration for Sport, which is the supreme arbitration body for the field of sport, which is recognized by all the main sport associations worldwide. So FIFA actually directs its members to solve their disputes by the way of arbitration before CAS, as Court of Arbitration for Sport is nicknamed, being seated in Lausanne in Switzerland. International Olympic Committee does the same, and so on and so forth. So the CAS is really the respective arbitration body for sport worldwide. But Mrs. Pechstein later on went on to argue that she did not go to the CAS out of her free will. As you may know, for submitting your dispute to arbitration, you have to have a mutual consent of all those involved in the proceedings before the arbitration court. And she said that there was no voluntary consent on her side to bring the case before arbitration panel, and that she was deprived of her possibility, her right to have the case dealt with by a state court. And it's still not fully finished yet, as I said, but the case went to the European Court of Human Rights. In 2018, it was decided, and not in favor of Claudia Pechstein. But what was interesting was that the European Court of Human Rights said that the arbitration within the framework of sport federations may not be the classical one. There are many other conditions which I'm not going to talk about now, but I'll just use one one term that is a type of mandatory arbitration, which is kind of a contradictory term if you consider what an arbitration usually stands for. And this mandatory arbitration, in fact, is something what is legitimate within the sport area and has a tradition and is based on other considerations as well. And as long as it fulfills certain criteria, it was acceptable for the European Court of Human Rights. But the European Court of Human Rights made an interesting reference, which I think quite well describes the perspectives that an athlete has, whether to become part of the pyramid or not. They say that the athlete is always confronted, and not only athlete, clubs as well, confronted with the following dilemma: to agree to arbitration, or, second option, practice his or her sport in a non-professional context. Presented with the choice between abiding by the arbitration or practicing the sport in the garden while watching competitions on the TV, an athlete who wants to play against real competitors will be obliged to opt for the first of those alternatives. Therefore, in fact, like to this mandatory arbitration. Yeah. And the final slide. Quo vadis, FIFA, where to go? FIFA, where are you going, FIFA? Not being applicable only to FIFA, and there may be other sub-questions as well. But I chose two of my favorite quotes for this final slide. The first one being taken from CAS decisions, Court of Arbitration for Sport, which were also concerning cases of suspension of Nigerian Football Federation. And I would actually disagree myself with the first statement. It says with the authority of CAS that the panel did not assess the validity of certain decisions taken in Nigeria on the basis of the rules of the Nigerian Football Federation or Nigerian law, because it would fall outside of the scope of FIFA's review, and therefore it falls outside of the scope of the review by the CAS. In other words, it says, in my opinion, that FIFA and CAS does not give a damn about the national law of the country, which I think, to me, is like a horrific statement, and I think it will be, in this particular case, it was not challenged, but in my opinion, I think this is not the way to go. I think it's like a dream come true for FIFA and these large sport organizing bodies or organizations, that they would have their own legal system, but I think they still have to stick to the existing rules of the national and international and EU law. And as an invitation for the next class, I think this last citation is very fitting. Since FIFA is virtually accountable to no one from the hierarchical point of view, and given that governments, with the exception of the Swiss government, because FIFA is based in Switzerland, have no supervisory powers over it, Indonesian government could tell, the only plausible route for the assessment of the proportionality of the statutes, and meaning all these requirements which FIFA may come up with, would seem to be through the legal accountability channel using EU law, especially its provisions on competition and internal market. So I'm leaving the gate open for the next topic coming in January on the competition law provisions of the EU in relationship with sport, and I'm closing my talk for today. Thank you very much.